I would like to introduce our presenter for this afternoon, Barbara Birchler. Ms. Birchler's practice consists of general business and commercial law, with a special focus on intellectual property law, copyrights, and trademarks. She has earned both a JD Juris Doctor and an LLM Master of Laws degrees. She was awarded the Brinks, Hoffer, Gilson, and Lyle Award for Excellence in Intellectual Property Law. So, Barbara, let's start.
Thank you very much, Janine. I appreciate the introduction. This is going to be a preliminary examination to enable you to be able to ask the right kinds of questions. You may not know the answers, but at least if you're aware that, hey, I have a question. Now, as I had said earlier, copyright attaches immediately. You don't have to do anything special. But it is helpful if you put a notice on the work, which you're telling people, I'm asserting copyright ownership in this particular work. So if somebody then copies or does something with your work without your permission, and you want to go after them for this infringement, by having that notice there, it goes a long way to prove that they willfully infringed. In other cases, it may deter some potential infringers. They see that you've taken the time, they're now on notice, so they back off. Now, what you would do is put the copyright notice on a published edition. And as each edition occurs, there could be subsequent registrations and so forth, or editions, but you would want to have that notice there. And what does the notice consist of? A copyright symbol, well known as the C in a circle, but you can write out the word copyright or an abbreviation, COPR, period, plus the year of the publication, plus the name of the person who owns the copyright. Next slide. And why, if I already own the copyright, why do I need to do anything else? And of course, the anything else is to register the work with the Copyright Office. Now, as I said, registration is not required for protection, for you to claim your ownership rights. But if you're going to seriously enforce them, then you need to do that. And as I said earlier, copyright is regulated by the federal government, and federal courts, in order for them to have jurisdiction, can only examine and look at a case where the work has been registered. So why you would do it is you can't file a lawsuit to enforce it without having registered. Having registered, you're indicating some information, and therefore certain proofs are easier for you to make. And if you register the copyright prior to an infringement occurring, then you can claim what they call statutory damages as well as attorney fees. Now, the attorney fees are not necessarily a given, but at least you can ask. Next slide. Okay, so now we've looked at copyright in a broad way. So what does infringement mean? What is copyright infringement? Well, it's when someone other than the copyright owner exercises one of the exclusive rights without the permission of the owner. In that case, they're an infringer. So now you're faced with an infringer. So what may you do? Well, you can certainly send them a letter putting them on notice. They need to cease and desist. You may enter into some kind of a settlement with them where they pay you a licensing fee. But if you're forced to go into court, you can ask to have them enjoined from using the work further. You can ask for actual damages. We talked about statutory damages and attorney fees, but those latter are only if the infringement occurred after registration.